2. The history of the corporate charter and its relationship to sovereign authority. The corporate form of business and the large corporations that increasingly control our economy and our politics did not always possess the almost unlimited powers that serve as their primary attribute today. The transformation of the corporate business form in America from the status of a relatively insignificant association to that of a dominant conglomeration of capital was a laborious one. Prior to the colonization of America, the English government had granted only a few charters of operation to businesses, two of which included the well-known East India Trading Company and the Hudson's Bay Company. With the emergence of America as a source for natural resources and raw materials, Britain began chartering the American colonies to strengthen the English claim in the new continent. These colonial charters, which controlled every activity of the colonial governments, restricted the powers of the colonies and limited their trading partners. The charter creating Maryland, for example, required that the colony's exports be shipped to or through England. The American colonies, following the experience of the English monarchy, began granting special charters through the colonial assemblies which outlined the specific purpose of and restrictions placed upon those groups seeking incorporation. Colonial law made no distinction between public or private corporations in that they both were chartered by the same method, through the direct vote of the legislature. The test for chartering was whether or not the corporation would perform a service for the public good. In return, corporations were granted the power to purchase and hold property collectively, and the right to sue or be sued collectively. Most importantly, they were granted monopoly privileges in the field of the charter grant. Corporations were thus utilized by the colonies for public or near-public purposes such as to build canals, bridges, or toll roads. They were strictly established by the legislature through the special chartering process, and were established for limited time periods. Under these limitations, the number of corporations remained small. By 1800, only 355 corporations were incorporated in the United States. Implicit in this special chartering process used by the state legislatures was the reserved legislative ability to revise or repeal the original charter. The importance of restoration of the colonial economy following the Revolutionary War stimulated an increase in the granting of corporate charters. Subsequently, there was a corresponding increase in judicial challenges to the state's legislative omnipotence over chartering powers. The quest for corporate independence growing from the economic necessity of the time period precipitated the 1819 landmark case of Trustees of Dartmouth College v. Woodward, in which the Supreme Court held that a corporate charter is a contract, the obligation of which cannot be impaired without violating the Constitution of the United States. Dartmouth College arose as a challenge to the New Hampshire legislature's attempt to revise the charter originally granted to Dartmouth College. New Hampshire originally chartered Dartmouth in 1769 at the request of Reverend Wheelock, who had raised private donations to establish the college. In 1815, the state attempted to revise the original charter after the Board of Trustees dismissed Wheelock from the presidency following a nasty fight between the two. The revision sought by the legislature would have provided for an increase in the number of trustees and would have created a board of overseers. The trustees refused to abide by the act of the legislature, and proceeded to challenge the legislative action in court, contending that the attempted revision of the charter was a forcible intrusion that violated the legal rights granted to them in the original charter. The trustees also argued that corporate franchises could only be forfeited by trial and judgment. In its ruling, the court laid the framework for weakening the common law principle of retention of sovereign power over state-chartered corporations. The reasoning in the opinion flowed directly from the court's strict interpretation of contractual principles. In response to the New Hampshire Council's argument that the charter was not a contract as is contemplated by the Constitution, but a grant of a public nature, Chief Justice John Marshall, in the majority opinion, replied that the corporation is no more a state instrument than a natural person exercising the same powers would be. Marshall reasoned that the Constitution of our country has placed corporate charters beyond legislative control. He proclaimed the necessity of inviolate contracts as a means for keeping the legislature from violating the right to property. Under what became known as the Dartmouth College Doctrine, a charter of a private corporation is protected by the Contracts Clause of the Constitution, and thus, legislatures are prohibited from revising or repealing charters once granted. The implications of the Dartmouth College decision were far-reaching. No longer would the corporation created by the sovereign be subjected to arbitrary interference. The corporation, instead of being viewed as a functionary of the state, providing goods and services that the state could not, began to assume an existence of its own. This posed a great threat to the state's control of corporate abuses, since the judiciary seemed willing to acquiesce to this autonomous existence and to reinforce this new paradigm under the rubric of contractual principles. The emergence of the Jacksonians following the Dartmouth College case was in part a reaction to the public outcry against the monopolistic hold being exercised by private chartered corporations. The Jacksonians wanted the advantages of incorporation to be readily available. The resulting General Incorporation Acts that swept across the United States during this period shifted incorporation from a privilege bounded by certain public purposes to a relatively unencumbered right routinely dispensed by the states. Many states, while adopting these acts, continued to limit charter purposes and duration. The state courts played a central role in this power struggle as states sought to curb the abuses of corporations which were acting outside or in violation of the scope of their charters. Many states pursued quo warranto actions, which allowed the state attorney general to revoke corporate charters for misuse or non-use. These ancient writs previously had been used by the English king to correct an abuse of office or franchise, and codifications of the writs found their way into colonial law. Quo warranto was used extensively by the states during the Jacksonian period to correct corporate and governmental abuses, since direct amendment of charters by the legislatures had been virtually foreclosed by the Dartmouth College decision. The 1855 landmark case of Dodge v. Woolsey, while not a quo warranto proceeding, provided the U.S. Supreme Court with an opportunity to further define the extent of corporate powers and the charter's role in determining the activities in which the corporation could engage. In Dodge, the court continued the progression begun by Dartmouth College toward the view that granting a charter to a corporation established a contractual relationship between that corporation and the state. These cases upholding contractual principles at the expense of state sovereignty set the stage for the loosening of state control over corporations. In Dodge, the court held that a charter provision setting the rate of taxation constituted a binding contract between the state and the corporation. In addition, the court held that the enforcement of these contractual limitations should be extended to those with an immediate financial interest, namely the stockholders. The court specifically held that a stockholder could intervene in a corporation's activities when the corporation sought to apply its capital to objects not contemplated by its charter. In Dodge, a stockholder of the commercial branch bank brought suit against the bank's directors for refusing to challenge a tax assessment made against the bank in violation of its original charter. The original charter had established that the bank was only responsible for payment of a charter-set tax. Woolsey, the stockholder, sued Dodge and other directors of the bank for refusing to take any step to prevent the threatened injury to the corporation. Woolsey argued that the new tax assessment violated the 10th section of the first article of the Constitution of the United States, which declares that no state shall pass any law impairing the obligation of contracts. In Dodge, the Supreme Court upheld the right of the shareholder to intervene, and declared that a shareholder may maintain a bill in equity against the directors and compel the company to refund any of the profits thus improperly applied. The court distinguished between error of judgments and breaches of duty, stating that the refusal to challenge the additional tax was a breach of duty, and therefore actionable. In the dissenting opinion, Justice Campbell supported the view that only the state has the power to challenge the actions and existence of the corporation. He stated that the allowance of this plea interposes this court between these corporations and the government and people of Ohio, to which they owe their existence, and by whose laws they derive all their faculties. Finally, he noted that the United States itself is responsible for curbing corporate abuses, and argued that no one else is in a position to determine when the public interests demand the suppression of bodies whose existence or modes of action are contrary to the well-being of the state. The decades following the Dodge case were punctuated by the capital accumulation of several corporations which began to pursue the emerging national market. The construction of a national transportation network, the completion of the first transcontinental rail line, the explosion of urban population, and the burgeoning power of the coal and oil industries contributed to the formation of the moniker of the times, the Monopolistic Trusts. These trusts sought to join independent producers to form one large monopoly which would be capable of setting prices and manipulating the market. In 1874, the Standard Oil monopoly was formed, in 1884, a Cotton Oil Trust was founded, and in 1887 the Whiskey Trust, the Sugar Trust, and the Lead Trust were created. People saw the trusts as a threat to fair economic competition, and viewed the monopolistic price-fixing nature of the trust's activities as contrary to free market principles. The states, prior to action by the federal government, enacted laws that prevented the formation of trusts. The federal government, under pressure from the general public, enacted the Sherman Antitrust Act, which made the trust business form illegal. Prior to the Sherman Antitrust Act's enforcement, states attempted to strike down trusts on their own. In 1892, the Supreme Court of Ohio attempted to strike a death blow to the Standard Oil Trust. In deciding on a quo warranto action brought by the Ohio Attorney General, the court stated that the acts of Standard Oil supporting the illegal trust arrangement could be challenged by the state, since they were an abuse of corporate power, ultra vires and against public policy. The court further ruled that the trust charter was void as organized for a purpose contrary to the policy of our laws, and that its activities must be conformable to the purpose for which it was created by the laws of the state. The autonomy of the courts and the extensive use of quo warranto actions by the state attorney general which occurred during this period represented the last act of the consistent exercise of state sovereignty over the existence of corporations. This occurred as corporations became increasingly visible players in state economies by providing employment opportunities and franchise tax revenues. The next decades brought an even more formidable challenge to those attempting to curb corporate abuses. By targeting the growing amounts of incorporation fees as a means by which to raise state revenues, the states engaged in a race to the bottom, in which they reduced their exercise of control over the corporate existence in an attempt to stimulate incorporations in their respective states. Delaware soon captured the lead. By 1932, more than one-third of the industrial corporations listed on the New York Stock Exchange were incorporated in Delaware. Finally, in 1963, in an attempt to fend off the efforts of other states to raid their incorporation coffers, Delaware enacted one of the most permissive corporate statutes ever. The legislature revised the General Corporation Law of Delaware to read that the General Assembly of the State of Delaware declares it to be the public policy of the state to maintain a favorable business climate and to encourage corporations to make Delaware their domicile. By 1971, franchise taxes comprised 23% of the entire state revenue collections for Delaware. While states such as Delaware were trying to attract corporations by becoming increasingly permissive with regard to corporate conduct and requirements, the idea of the federal regulatory state was developing. Under the regulatory state model, the government initiated programs through which it sought to control the conduct of private parties, such as corporations, in order to achieve governmentally determined goals. Legislation such as the Federal Water Pollution Control Act, Clean Water Act, has attempted to regulate corporate impact on the environment by the use of a penalty and permit program with varying effectiveness. State statutes, authorized under federal laws, deal with the management of the environment and the liability of the corporation for various abuses. State permit programs allow for criminal and civil penalties against a corporation for its violations, rather than merely noting the corporation's transgressions and waiting for the Attorney General to bring an action. The economic and political control exerted by corporations forced a virtual withdrawal of charter revocation actions altogether, leaving the states with one feasible approach: a program of secondary interventions in which they were forced to curb corporate abuses after the fact. Concern over the effects of this corporate economic and political invasion was voiced by Justice Rehnquist in First National Bank of Boston v. Belity, when he stated that the states might reasonably fear that the corporation would use its economic power to obtain further benefits beyond those already bestowed. The decline in the use of quo warranto actions by the state attorney general to dissolve the corporation was thus primarily caused by two factors: the increasing involvement of corporations in state economic and political affairs, and the rise of the regulatory state approach to monitoring corporate activity.